as Don said, Clint, Eric, and I are all with the Transportation Division of the Attorney General's office. And some of you may not know that much about our office, so I just want to give you a little information about that. The Attorney General represents the state in all of its agencies whenever they are involved in litigation. The Transportation Division has 42 attorneys who, except in with rare exceptions, only client is TxDOT. We represent TxDOT in courts and administrative proceedings all over the state, handling every type of case imaginable. Obviously, we do a lot of condemnation, but we also do personal injury defense, workers' compensation, highway damage claims, employment law, contract law, administrative law, billboard regulation, and bankruptcy. And there might be some subject areas that I've missed. So, and if for you TxDOT employees out there, if somebody wants to take your deposition, say in a case where TxDOT is not a party, we will go with you and be your counsel at that deposition. Now, one of the many things we do is represent TxDOT in the appellate courts. And appellate cases are special for a couple of reasons. First, an appellate case is in the second phase, where there's usually already been a trial. So we're either trying to hang on to a hard-won victory or reverse some sort of unfair result. The second reason that they're really important is that appellate courts, unlike trial courts, have to give reasons when they make a decision. And they put all those reasons in an opinion, and those opinions can affect future TxDOT cases. So I'm going to talk about the four most recent appellate opinions out of the courts of appeals involving TxDOT. And then Randy Ward, he's going to talk about a really important decision out of the Texas Supreme Court involving TxDOT and the valuation of billboards. And then Clint and Eric are going to give some practical advice for engineers and right-of-way agents if you are so lucky as to be called as a witness in a deposition or at trial. And just as a way of disclaimer, these opinions are my opinions, not the opinions of the Texas Attorney General, even though his name's up there. All right, the first case I want to talk about is a case called State versus Treeline Partners Limited. This involved the acquisition of some property for the widening of US 290 in Houston. And at jury trial, during the jury voir dire, which is a time when the lawyers get to ask questions of the potential jury members, the landowner's counsel asked numerous questions implying that the state underestimates damages in condemnation cases. Then when it was the state's turn, the state's counsel attempted to ask the potential jurors whether any of them thought that the state lowballs. In other words, did they have a pre-existing belief that the state underestimates damages in condemnation cases? Well, the trial court didn't like that and told state's counsel in no uncertain terms that if she asked that question, she actually would be held in contempt of court and be going to jail. So during closing argument, the landowner's counsel, I would say, made the unwise decision to actually argue to the jury that the state's appraiser went out of his way to justify his lowball numbers. And the jury awarded $4.8 million in that case, which was about twice the amount of the state's testimony of what they thought the landowner was entitled to. The state appealed to the Court of Appeals in Houston, and the state had a number of arguments. But the one that the Court of Appeals seized on was this issue about the questioning of the jurors. And the Court of Appeals reaffirmed the law that a party has a right to ask the jurors questions to uncover bias or prejudice and to give the party an ability to intelligently exercise their strikes. In other words, to decide that maybe somebody wasn't the best person to be on the jury and prevent that person from being on the jury. The court held that the trial court's ruling prevented the state from uncovering any bias or prejudice and from possibly, exercising strikes against somebody that already had a bias against the state, and that the state had been denied the right to a fair trial. The case was reversed and the state was granted a new trial. The landowner filed what's called a motion for rehearing en banc and in the Court of Appeals, and that means that their motion was addressed to all 9 members of that court, all of the 9 justices, not just the 3 that heard the case. And just very recently, the 9 members denied that motion for rehearing. The landowner can take that on to the Texas Supreme Court. We don't know if they're going to take that step at this point. The next case actually involves an SPV project case. The name of the case is State versus Titan Land Development, Inc. And this is probably it might be important to right-of-way agents because it deals with some of the procedural complexities involved in working a condemnation case through the court system. It involved the acquisition of about 85 acres out of a very large tract of property for the Grand Parkway in Harris County. The special commissioners awarded $7.5 million, and that was about 30% more than the state's testimony at the commissioner's hearing. So obviously, the state wanted to take the next step and file objections. Now, the property code has a couple of different provisions that affect the filing of objections. And one of them provisions tells the commissioners that they're supposed to file their award on the same day that they sign it or on the very next day. And then there's a provision that says that if you want to file objections to that award, that you file it on the Monday following 20 days after the award is filed. So the state took possession of the commissioner's award, and even though the statute says, commissioners, you go file this award, commissioners don't do that. They're lay people. They have no idea where they would file the award. And now that we have electronic filing, it's really only lawyers and lawyers' offices that can actually file things in the court system. So it's always been the practice that the condemnor takes possession of the award and gets it to the court system. And in this particular case, for some reasons that are really somewhat irrelevant given the status of the law, the award was not filed on the day of the hearing or the day after the hearing, but instead it was filed a few days later, the next week. And the state counted its deadline for filing objections from the date of the filing of the award and duly filed objections within that time period. So the landowner decided that it thought the state was late, and it filed a motion for entry of judgment in absence of objections, saying that really, don't follow the statute. Let's calculate this deadline as if the award had been filed on the day of or the day after the commissioner signed it, and you would have had a different deadline, and your objections are actually late. Well, the state disagreed, saying the deadline is calculated from the date of the filing of the award, just like the statute says, and the lapse of time between this earlier deadline was really irrelevant. And there was actually a court of opinion from the Austin Court of Appeals on that very issue supporting the state's position. It didn't apparently carry much sway in Houston because the trial court ruled for the landowner and a judgment in absence of objections was entered. The state appealed again to one of the courts of appeals in Houston, and the Court of Appeals agreed with the state and said, you calculated the way the statute says to calculate it, and don't pay any attention to this delay between the other deadline dates. And it said, do that because that's what the statute says, and it says this other deadline, there's no remedy for it, and there's no penalty for it, so that the court can't just make up this penalty for having not met the prior deadline. And one of the big arguments that the landowner made was there's this case law out there that says, oh, you're supposed to interpret the property code for the benefit of the landowner. And that is true, but the courts that said that were not intending that landowners use that as sort of a sword instead of a shield. I mean, you can do that when it benefits the landowner so they don't lose their right to object, but you can't use that concept to try to take away the state's right to object to a commissioner's award. And so the Court of Appeals pretty much said that in its opinion. The case was reversed. The state's objections were reinstated. The landowner has filed a petition for review in Supreme Court, which is now pending. The third case, unfortunately, is a case we lost, but it wasn't. It was only on sort of a small issue of principle that I don't really think is going to affect us in the future. But just so you know, this situation about driveways that can come up. This was an acquisition for the widening of US 290 at the intersection of 290, 610, and Old Katy Road in Houston. The subject property had this long, narrow warehouse on it, and for some reason, over the years, the property owner had managed to put in 9 driveways. It's unclear whether the property owner had actually gone through the process of obtaining driveway permits for 9 driveways, or this was just something that had been grandfathered in. But the landowner had 9 driveways. And at trial, the state testified that pursuant to its policy, that it would actually reestablish all 9 of those driveways. Well, apparently that wasn't enough for the landowner, because what they did is they got the court to enter a judgment saying that title to the property was subject to the restoration of the 9 driveway locations. And the state certainly didn't agree with that, and took the position that really putting that in the judgment gave the landowner more relief than it was entitled to. It was the state was entitled to get title to the property after it paid the money, not after it finished building its project, including the restoration of the 9 driveways. Unfortunately, TxDOT had already rebuilt the 9 driveways. So the Court of Appeals took the position that the whole issue was moot, and that whatever decision they made wasn't going to really affect this case because the driveways were already built. And so they basically just said, we're not going to hear this, and denied the state's appeal. Finally, one case from up in North Texas, and this is called Sloan Creek 2 versus the North Texas Tollway and the state of Texas. This case involves allegations of erosion. We have Sloan Creek running near the interchange of State Highway 21 and US 75 in Collin County, and as part of the Sam Rayburn Tollway project, TxDOT was converting State Highway 121 into a tollway and constructing a new interchange. The project was awarded to NTTA and was designed by them, and construction was overseen by engineering firms hired by NTTA. The project included both roadway surface and a drainage system that was designed to discharge rainwater into Sloan Creek. As part of the project, NTTA sought to acquire an easement from the landowner for the drainage system. The landowner filed both a counterclaim against NTTA and brought TxDOT into the suit as a defendant, also saying that the increased rainwater runoff would actually increase the amount of erosion on the landowner's property, resulting in an inverse condemnation. So both TxDOT and NTTA filed what is called a plea to the jurisdiction, basically where they said, you don't have a true cause of action here. And that was taken to the trial court. And after a hearing, the trial court agreed, dismissed the counterclaim and the new claim against TxDOT, and the landowner appealed to the Court of Appeals in Dallas. The Court of Appeals affirmed the trial court's dismissal and said, just the fact that this rainwater is being discharged into Sloan Creek, that in and of itself, that's not an inverse condemnation. And then, one of the big elements in proving up an inverse condemnation is you have to show intent. So most of the rest of the opinion had to do with whether intent could be shown. And what the court said is that you can't show an intent to cause erosion simply because erosion may have been caused. The second thing, you can't establish this intent element by saying that TxDOT and NTTA should have known that erosion would be caused. And the court also found that the landowner had not even raised a fact issue about TxDOT and NTTA's knowledge of whether the project was substantially certain to cause greater erosion than what occurred without the project. And just to sum up, the Court of Appeals wrote this great long opinion, and one of the things they did was cite a statement that had been made by one TxDOT engineer in the case. And what the court said, which was what had been said by a TxDOT engineer, is we cannot model the entire world. Thank you.